legally speaking, with me, Tarun Nangia. Today, we discuss a judgment which is authored by Chief Justice of India, Justice Sanjeev Khanna, Justice M.M. Sundaresh, and Justice Bela Trivedi. This judgment is titled Radhika Agarwal versus Union of India. Most importantly, it concerns the constitutional validity of the powers to arrest under GST. Powers to arrest and liberty, as we have always discussed, are a very important topic. The powers to arrest itself is a very, very strong power, and how it is used has an impact on everything from investments in India to how the countries look. That's why we take it up today, and we will discuss this judgment. I want to welcome Advocate Mukesh Bhutani, who's an expert on the subject, who joins us today. Good to see you, Mr. Bhutani, and thank you for your time. We have with us Justice Chellako Ram, who, as all we know, is also senior advocate at the Supreme Court and High Court. Good to see you, sir, and looking forward to your interesting insights and your analysis of what our panelists say. I want to welcome Advocate Aditya Ajgaonkar, who practices on the tax side from the city of Mumbai. Good to see you, Aditya, and looking forward to your interesting insights on the tax front as usual. And at the outset, let me request Advocate Mukesh Bhutani to come in and give us an introductory comment before we go to Aditya, and then Justice Chellako Ram for his summing up of the arguments. Over to you, Mr. Bhutani, for your opening comment.
Thank you, Tarun, for inviting me. First of all, we need to understand the context of this decision. This concerns interpretation of Section 69 and 70 of the CGST, the Central GST Act. This was challenged because when the GST law was designed, there were certain offenses, let's for the sake of argument call that as scheduled offenses, like fake invoices, wrong credit, which were punishable. And for going through that process of criminal law, you need not go through the entire procedure established under the Criminal Procedure Act. And hence, the question was whether you can have a law that can have wide arrest powers given to the authorities for these forms of scheduled offenses. This came up for challenge before various high courts, except that the challenge that came up before the high court was whether a bail can be granted in those cases or not. Obviously, there were conflicting views of the high courts. This was before the pre-COVID era, and in the post-COVID era, this came up for a debate before the Supreme Court. And the Supreme Court was examining this question under Article 21. And the question was whether under Article 246 of the Constitution, which gave the legislative power for implementation of GST, whether you can have a power under the GST law which could curb the question relating to personal liberty, and whether this article, this section of the GST law in pursuance to Article 246A, which signaled the implementation of the GST, came in breach with Article 21 or from a personal liberty standpoint. So really, Tarun, let me pause over here, but this was really the question before the Supreme Court.
Thank you for that opening comment, Mr. Bhutani. I'll go to Advocate Aditya Ajgaonkar for his opening comment. Over to you.
Tarun, it's very interesting. There's obviously the judgment is divided into two parts. One deals with customs and the other deals with GST. According to me, though the customs one is fairly important and we'll touch upon it, the GST one is very, very interesting. Mainly because it lays down very specifically that if you have apprehension for arrest under the GST, you can move an application for anticipatory bail. The reason why this is so important is because there were two judgments of the Supreme Court saying that no, you cannot get anticipatory bail in GST offenses if you have been summoned to give evidence by the GST authorities. And they said that because at that point of time, you are called only for investigation, you may not necessarily be an accused. Not that they said that, liberty is not paramount. Those two judgments said that you can obviously avail of your constitutional remedies to ensure that, your right to life, Article 21 with dignity, is not done away with completely. But this judgment, which is a three-judge judgment, reaffirms the fact that anticipatory bail can be granted for GST offenses. And according to me, that is why this is to be considered landmark. It also is very interesting how PMLA has played a very important role in the analysis out here. Arvind Kejriwal judgment has been cited. Vijay Madan Lal Chaudhary has been cited. And Mr. Bhutani will attest to the fact that, every tax lawyer knew the statement, this phrase, which has now become a catchphrase everywhere, reasons to believe. In the earlier regime, before the amendment to Section 148 of the Income Tax Act, every tax lawyer worth his salt had a file full of judgments for reason to believe across high courts and the Supreme Court. And what the government did was it made all of them redundant by amending the Income Tax Act, and made sure that now, what is required under income tax is information. But then PMLA came, and the PMLA uses reasons to believe in a majority of places. GST reasons now with respect to arrest requires reasons to believe. Customs with respect to arrest requires, reasons to believe.
I'll go to Justice Chella Kodanram, sir. When this law came into force, you were a judge of the High Court. So you would have seen how it has been applied in arrests and all. You would have been witness. Now you're practicing as a senior advocate. Could you analyze it from both points of view, from the point of view of the bench and also now as practicing advocate?
Well, Mr. Tarun, it's a very welcoming judgment from the point of business community and also the society. Yes, my two friends have already said, with regard to the reason to believe, a innumerable number of cases in the Income Tax Act especially. And there's also different opinions expressed, and that is, in the end, ultimately, it all depended upon the individual judge's approach to the reason to believe. It was highly subjective. Though there were in the earlier stages of Income Tax Act, they were very strictly applying the reason to believe for concept. Thereafter, a large number of court cases went in favor of the revenue, to be honest, rather than thing. And that was the reason to believe has been made, very diluted version. But most important thing, present judgment is concerned, when they talk about Article 21, I always keep wondering, in many of the English movies when you watch, or in American movies when you watch, the first thing when the police officer goes to arrest, what he says to the person who is getting arrested, the standard one, you have a right to keep silent. You have a right to protect yourself. These are all repeated in a manner, in such a way that the safeguards which today the Supreme Court has come out after how many years of independence. In many of the cases, not only in the cases of tax laws, even on a routine cases also, I always wondering, so far as personally, I always felt arrest is something which is in extraordinary circumstances. Justice Krishna Iyer said in a classic judgment, the bail is the rule. Keeping a person in this arrest is a exception. Why? That is because the liberty of the person is the most paramount. More particularly in cases of economic offenses, unless the person is likely to flee from the country, anywhere in the India, the officers are capable, if they're really honest and sincere, they are capable of catching the offender, whoever is evading the thing. The volume doesn't much matter. For a con man, volume doesn't much matter. It's only just a figure. It could be 20 crores, 30 crores, or 50 crores, 100 crores. The mechanism which you create, the robust mechanism which you create, and you leak-proof mechanism which you create is more important and that lies with the administration rather than with the courts or others. In the end of the day, what the Supreme Court has said, because of considering various aspects and also considering the business environment, these judges have been more bold in categorically stating enough is enough. I think we have given enough of the leeway to you authorities. Now let's go in the more in favor of the system, the real system where the liberty is protected. That's how I look at it in the overall analysis.
Point very well taken. I'll go to Advocate Mukesh Putani, who will reflect on the implications of this judgment delivered by Chief Justice of India, Justice Khanna, Justice Sundaresh, and Justice Bela.
So while I hear that the Supreme Court has taken a very narrow view, we, in order for this balanced debate, should not also look at the criticism that has come in for this judgment. I think the first criticism that's coming in is with regard to the Supreme Court in this case relying heavily on the Arvind Kejriwal case. Now, we have to remember that Arvind Kejriwal's case was tested in the context of PMLA law. And the question that comes up for debate is whether the GST and the customs are punitive laws like the PMLA laws. Or could the arrest under PMLA be treated on the same pedestal as arrest for an economic offense under the customs and the GST law? Up until this judgment, it was believed that there is more reasonableness required when it comes to taking punitive action against a GST and a customs law, and there are established precedents for that even by the Supreme Court in the context of customs law. Also, we should not forget that in Arvind Kejriwal's case, the issue before the court was denial of a bail, whereas the issue in this case was constitutionality of a constitution amendment to roll out the GST law, which gave powers under the GST Act for arrest. And the Supreme Court in this three-judge bench judgment, by upholding the constitutionality of the law, has in other words signaled a very strict interpretation of economic offenses like the GST law, virtually on par with the PMLA law. Now, to some extent, experts, differ in their view, and the view is that this is clearly an apple and oranges comparison, because how can a judgment rendered in the context of a bail application versus a judgment laying down the law for citizens at large on a constitutional challenge be treated on par? In my view, on the point that was made earlier on reasons to believe, this reasons to believe has been subject matter of interpretation of at least couple of hundred High Court judgments, probably 50 Supreme Court judgments, because it is vague, it is subjected to a lot of interpretation. So I think that the Supreme Court probably in this judgment has mixed up two questions. One, the level of satisfaction. Two, versus the recording of reasons for arrest. Consecutively, in several Supreme Court judgments, particularly the landmark judgment in D.K. Basu's case, it was very clearly laid down that those reasons have to be articulated very clearly. What is the ground of arrest? And that is critical. In a very landmark judgment of Delhi High Court in the Make My Trip case, that's what the Delhi High Court said, which was further affirmed by the Supreme Court. The Make My Trip case was under the Service Tax Act, and in this case, an arrest was being effectuated without raising the demand, which the Delhi High Court held to be unconstitutional, and subsequently the Supreme Court approved it. So to some extent, we should look at this judgment as something which is a red herring, which is a warning, because that's how the Supreme Court has interpreted it under the GST law.
Thank you for that interpretation of the judgment and its implication. I'll go to Advocate Aditya Ajgaonkar for his interpretation on the impact of this judgment on other cases and future cases. Over to you, Aditya.
Thank you, Tarun. Before getting into specifics, I'd like to administer broad strokes, brush strokes first. And for that, it is very important to understand that GST doesn't treat all offenses alike. You know, the offenses below 5 crores are considered lesser offenses than offenses above 5 crores, right? Which is a very interesting aspect, because the second the 5 crore threshold is met, especially for the first four offenses in section 132, the offenses become non-bailable. If it's below 5 crores, they became bailable, right? Uh, you know, Lawyers love to argue how unconstitutional this would be because it would be violative of Article 14. But there is a method to the madness. There is, every time there's a question that comes under PMLA, people ask me, is there a threshold? I say no. Between 1 crore and 100 crores and 1,000 crores, PMLA doesn't really distinguish. On the other hand, GST does. And according to me, that is a very, very important safeguard that that GST has. And I think it is very relevant because these acts, very wide-ranging powers have been given to officers that are not police officers. You see, a very important aspect that has been covered in this judgment and reiterated after countless times are the fact that officers of GST department, officers of customs are not police officers. In fact, this is, let's harken back to Vijay Madan Lal Chaudhary that says officers of ED are also not police officers when it comes to PMLA. And in fact, before that also, under FERA and FEMA, it has been held that officers of ED are not police officers. Therefore, a large section, a large part of CRPC that used to give certain protection, there was a gray area about what sort of protection can be given to people who are then, sought to be arrested by these special officers who've been given power of arrest under these special acts. And I think that is where this judgment shines, because it puts procedural safeguards in place. It gives a very broad-based instruction, including what protection are available to women. Women cannot be arrested without, a lady officer being there. What is the procedure? Whether grounds for arrest need to be given? What sort of sanction is required? And most importantly, I think the real interesting part that is there in Radhika Agarwal is the Supreme Court saying that the power of arrest should be used with great circumspection and not casually. The power of arrest is not to be used on mere suspicion or doubt or even for an investigation when conditions of subsection 5 to 132 of GST Act are not satisfied. And I think this is a very, very important safeguard. There's a lot of questions that keep coming about whether an arrest should be made just because an arrest can be made. What actually constitutes an arrest. And that is extremely important that this judgment reaffirms this, especially because they also rely on the Arvind Kejriwal judgment to say that you cannot turn a blind eye to that material that is in favor of the person you're accusing. The evidence must be weighed as an whole. And this is very important because reasons to believe, right? The jurisprudence, as Justice Chilak Kodaram had already said, the jurisprudence with regards to reasons to believe also said that you cannot go into the merits of reasons to believe. You have to see whether there are reasons to believe or not. And that had diluted away a large part of reasons to believe. But there are now some inbuilt safeguards, that are built in. And this is more relevant because now it is not just about how much tax is put. My personal liberty can go for a toss. I may be arrested by GST officers, right? I may be arrested by customs officers. Are those grounds to be, for my arrest to be noted down in writing? Are they to be given to me? And otherwise, if they are not given to me in a case of a non-bailable offense, how do I seek bail? This is something that is very, very important. And we have PMLA to thank for this, honestly, because a lot of PMLA jurisprudence has been borrowed. So I will just say one thing, Mr. Mukesh Bhutani also brought this up. PMLA, what do you call it, principles are being, imported to GST and customs for us. I would welcome that, because if there are safeguard that is important in a act that is as aptly described, as a dangerous one, as PMLA, then it should therefore definitely be incorporated even for these acts that may not be as bad as PMLA. Before I stop, there's just one very important thing I want to bring out. There are two judgments in this one judgment. So the concurring judgment was passed, which brings an emphasis back on why special legislations get a leeway, because when special legislations are made for a specific object, they override general law, and they should not be interpreted in a way that takes away the special reason for which they are legislated. And that again brings me back to the Vijay Madan Lal Chaudhary judgment, where this exact reasoning was used again and again to justify the provisions in PMLA. And I will end with one, very important quote that I keep using. The Supreme Court, when this entire line of jurisprudence started out about how special acts, special purposes, and economic offenses, how economic offenses are so grave, said that a murder may be created, done in a heat of a moment, but an economic offense is done with cold, deliberate calculation, and it affects everybody, which is why economic offenses are so dire. So, it all ties together very well, but I'm glad that the jurisprudence is evolving.
Thank you, but you're right indeed. With every judgment, and most especially this one, jurisprudence with regards to PMLA now, arrest powers is evolving. We'll go to Justice Chella Kodandram for his comment.
See, so far as the upholding of these provisions with respect to arrest, either in the economic offences courts, taking into purpose into consideration, probably goes against the larger constitution bench judgment in 1970s, if I remember right, or somewhere in 1980s, Bengal immunities case. See, if the purpose is to be taken into consideration for the purpose of upholding a particular law, which act says the purpose is bad? Every act has got a purpose of curbing something or something good for the society. Supreme Court said, no, that cannot be the test. For testing the constitutional validity of a provision, what is the effect of that the provision on the citizen, and whether it is impinging the other rights of the constitutional rights of the citizen is more important. That is the one which is required to be considered. The evolving jurisprudence, every judge is saying that these have to be interpreted based on the purpose for which they are enacted, is according to my understanding, goes against the constitution bench judgment of the Supreme Court. The Bengal immunities case, they categorically dealt with these aspects. There can be no law or no act, then in which case can be struck down on the ground that it has been enacted for a particular specific purpose. So that purposive interpretation is, according to me, is not correct.
Okay. Point well taken. We'll go to Advocate Mukesh Bhutani for a closing comment on today's issue.
Well, I think as I see it, this judgment is a watered down protection now, which was given at least in the context of service tax by Delhi High Court in Make My Trip, which was further affirmed by the Supreme Court. This also, in a way, overrides some of the other earlier judgments of the rendered in the context of customs law. For example, in the context of customs law, it said that if the arrest has to be made and the punishment is less than 3 years' time, then until and unless you get a magistrate's order, no arrest can be effectuated. This also, in my view, comes partly in friction with the D.K. Basu judgment, which is hailed still today as a mother of all citizens' right. And this judgment said that more than reasons to believe, it is actually the recording of the reasons which are the grounds of arrest. And that, because that impinges on the personal liberty of the citizen. So that also sounds a little bit on a shaken foundation. In fact, after the Om Prakash Customs decision, there were amendments that were carried out to the Customs Act, which clearly confirmed that if it is something to do with an offense which is less than 3 years and it is bailable then you cannot arrest a person. So I think there are divergent views about this judgment. I personally feel that this judgment affords an opportunity to the lawmakers to intervene and clarify, because you do not want an unintended consequence of this judgment. As somebody earlier pointed out, the officials in the GST department and customs department clearly are not trained police officials, and you may have unintended consequences of this, wherein if this excessive delegation power is exercised, it could be open to misuse and abuse.
Point very well taken. In fact, we may also want to do a show where we discuss whether the threshold for arrest should go up from 5 crores to a more reasonable amount. Maybe 5 crores looks too less. Should that go up? But that's for another date. This was an important judgment by Chief Justice of India, Justice Khanna, Justice Sundaresh, and Justice Bela Trivedi. We took it up. We will maybe do a further show for, in a sense, assessing the impacts of this judgment and the kind of arrest powers that are being used by GST. Are notices given, or there is a threat of arrest always? Does the GST department give a notice? All of that and more, maybe on the next show. I appreciate that Advocate Mukesh Bhutani, Justice Chella Kodandram, Advocate Aditya Ajgaonkar, you joined us. You gave your comments on this important judgment that concerns liberty. As we always said, vote for liberty is a thumbs up for investment in India, because people do concern and assess these things when they make investment in a country. That's why liberty remains very important at a time when we need money to come to this country. Appreciate you joining us. Thank you so very much.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.